All right, folks, welcome back to my channel. I am on vacation and I unfortunately got super sick, so I'm not going to turn the camera on because I look like hell. I will save you from that shock and horror, as they would say in Boston. Anyway, there's a ton of stuff that happened in the Jeremy Hales case in federal court, so we're going to get to it right now. Now, if you are tuning in right after Tug's broadcast, he went over all of this in great detail with you, but you know me. I've got to get my thoughts in here. All right. So, last we left off, Randy Shockett had filed a motion for sanctions against Bruce Manskin for his horrific behavior towards not only the litigant, Jeremy Hales, but also Jeremy's lawyer, Randy Shockett. And the judge ordered a show cause hearing, which is to be on April 3rd. Now, the judge also wanted Bruce to respond, and he gave him 5 business days. This is what Bruce put into the court. It is a motion to strike 96, document 96, which is Randy's motion for sanctions, for failure to include Local Rule 7.1c certificate and request for 1 week to respond if motion to strike is denied. So he wants an extension of time if this motion to strike the whole thing is denied. So basically, I'm not going to read this word for word. He's basically saying that a certificate is required, that they conferred, and Randy didn't do that. And so because of that, he wants it struck. But then he does a very strange thing. He should have just ended it there. But now he says he's starting to explain himself. So in other words, it's almost like he did respond, but this is not his response. It's very strange. So he says the motion was a complete surprise. If there had been a Rule 7.1b conference, then the undersigned could have responded in writing to memorialize efforts to narrow issues and avoid motions. Then he basically responds while saying he needs more time to respond. Here are his excuses for why he behaves so abhorrently. In document 96-1, the exhibit, he says this is an email sent as a litigant who was served process in a different case, not as counsel and not in this case, and thus not to opposing counsel. It was in response to learning that home addresses of 10 individuals, all of whom have been the subject of ongoing relentless vitriol, invective, and threats by the plaintiff on his YouTube platform, and resulting threats, accusations, and vulgar comments from the plaintiff's fans and supporters online were publicly docketed in the other case, possibly with the intent of being doxxed by the plaintiff's supporters. The addresses were removed following the undersigned's email. Well, I just want to put in here that we always redact addresses, and we always have. So if the fleas didn't, that's on them. And if other people didn't, that's on them. But we certainly didn't do that. And by the way, like we've gone over a million times, addresses are not private information because they're available on multiple public records. And so they're not considered private information. This argument fails on a lot of levels, but the most glaring is him saying that because he responded not as counsel, not in this case, this is a problem right here. You know why, Bruce? Because you are a lawyer. You are a member of the bar. You are a court. You're an officer of the court. No matter what you're responding to and when, you're acting underneath the rules of ethics and you have to comply. It doesn't matter if you're not the lawyer in this case. You are a lawyer. So you need to act like one at all times. That's how this argument fails completely. He's saying the court's jurisdiction does not extend to private communications of the undersigned sent as a litigant unrelated to this case. This is false. And if you go back to his disciplinary hearings in Connecticut, he tried to use this exact same argument, and it failed there too. The court said no. The court said, no, you are an officer of the court, and all of your communications are subject to our jurisdiction. Yep. And then he says, 96-2, you're endlessly ridiculous. He pleads guilty to that. The plaintiff's counsel has been demanding better responses to discovery requests, and the undersigned had been asking him to explain more specifically what he was seeking. After a number of such exchanges, plaintiff's counsel emailed to inform him that he would be sending a formal deficiency letter. Yeah, because they refused to turn over the discovery. So that's what you're supposed to do. You're supposed to then go and file a formal deficiency letter if the other side hasn't turned over sufficient responses. He continues to say the undersigned's full response was, you continue to refuse to explain what you claim is deficient and what better responses mean. And that's not true. We've seen these communications. Randy very clearly said, you know what I'm looking for. These answers are perfectly legitimate. They're perfectly easy to understand. Please just hand over the information. Bruce is claiming this doesn't warrant sanctions. Well, that's up to a judge to decide. 96-3 says it was an email sent in a continued effort to obtain a copy of the only contract from Whatnot identified by the plaintiff as underlying the tortious interference counts, without needing to burden the court with motions. Since November, the plaintiff's counsel has not provided that contract or taken steps to procure an order of protection of confidentiality, which he claims is needed. Oh no, Bruce refused to sign that order of confidentiality. Remember? He refused to sign. He would only agree verbally. And then he claims, he's lying here. He says, to be clear, the undersigned from the very start offered in writing to maintain any Whatnot documents as 100% confidential. No, but he didn't. He was told, you have to sign a document that says that, and he wouldn't do it. He said, it's enough that I just told you I would. Meanwhile, every time there's anything that happens in this case, he hands it off to the fleas who have it and go live with it. So, of course, he's not trusted. As of the date of the email, an inordinate amount of time had been spent attempting to resolve this discovery issue, and the undersigned concluded that the purpose of the obstruction was to create an issue for court motions. Thus, I realized your conduct is always intended to create issues for motions to generate YouTube conduct. Pile them up. And here he goes. He's going to try to make fetch happen again. Look at his footnote. Polymat stands for protraction of litigation and multiplication proceedings and has become commonly used. Commonly used? By you? Just by you. It's not commonly used. Nobody else uses this, Bruce. Nobody. Commonly used to describe the plaintiff's and his counsel's use of litigation based on contrived claims. He's doing it again. He's doing it again. You can't say that your opponent is contriving claims. You can't. This is against ethics rules. He's doing it again in this response to generate litigation-related YouTube content, which the judge in this case has already told him, I don't want to hear about this anymore. I don't want to hear about YouTube content. I'm not going to hear anything about this guy's free speech. We're not taking that away from him. So stop. But he doesn't stop. He keeps going. I need my blood pressure cuff. I can feel it rising. The plaintiff's motion and court's order are presently the subject of extensive coverage on numerous YouTube channels. Yeah, so what? So what? That's life, Bruce. You've got a publicly interesting case here that the public has a right to know about, has a right to follow, and we have a right to talk about it. For whom this litigation has become the near exclusive source of content for the entertainment of their subscribers. So what? So what? We covered, there are channels right now exclusively covering Blake Lively and Justin Baldoni, and they do it all day long every day. And guess what? There's nothing wrong with that. We are allowed to find court cases that we find interesting and cover them exclusively. That is not against the law, and even putting this in here is laughable, and I hope that the judge laughs him out of the courtroom on April 3rd. He says there's nothing vulgar or insulting about Polymop. I think there is, though, because he says right here, he's claiming that their claims are contrived. So to me, that is insulting. Yes. And he's saying it doesn't justify a motion for sanctions. the email in 96-4, the email from plaintiff's counsel states, "We disagree. Your offer is also rejected." In response to the undersigned wrote Palomop. Without the context, the court cannot know that the offer was rejected or if it was intended to resolve some claims by agreement rather than multiplying litigation. Blah, blah, blah. This does not hold water. 96-5. Here he goes. The eggplant emoji was in an email from a journalist. Oh, a journalist? A journalist? Oh, Bruce, you know damn well that he is not just a journalist. Paint Chips he's a convicted extortionist and stalker that you have somehow gathered into your anti-What the Hales Media Inc. ecosystem and sicked on Jeremy Hales. He's not a journalist. He's a fake. Paint Chips is a fake. He is a fraud. He is an ex-con. He's a disgraced former attorney that was disbarred. And since he was brought into this case by you, Bruce, he has threatened me, Jeremy Hales, that umbrella guy, all of us with violence. He has made revenge, you know what, digital images of me and Jeremy Hales in illegal situations, which I can't even say on YouTube because I'll get demonetized. But you know what I'm talking about. This is someone who has already broken the law, and he's going to break it again. Clearly, he's not a journalist. This guy is a fraud. So he says, was the undersigned obligated to respond to Mr. Lickman? I want to make it clear that I do not adopt your eggplant emoji signifying a weenus. It is ludicrous to bring a motion for sanctions based on this. Is it though, Bruce? Because you should have said something like that. Yes, you should have. Instead, you encouraged him to continue his harassment of Randy Shockett and his harassment of Jeremy Hales. You encouraged him to continue it. You should have, at that moment that you saw that he was accusing people of giving you know what kind of favors in exchange for coverage and whatnot, you should have been like, oops, I've made a huge mistake. And I totally disavow this man and his tactics. Yes, as an officer of the court, you should have disavowed him immediately and never spoken to him again and apologized for bringing him into this. That's exactly what you should have done. The motion highlights the suggestion that the journalist, wow, is that word is surely being used incorrectly, questioned the plaintiff's counsel about plaintiff's perjured affidavit. Again, there was no perjury in that affidavit. And you saying there was doesn't make it so. And what that is simply an allegation with no evidence. He says this is not a communication in these court proceedings. It's a response to a journalist's question, not subject to the court's control. The remaining highlighted parts were contained in the email from the journalist along with the eggplant, not in the email from the undersigned sent in response. Footnote number 2 says, respectfully, the inclusion of this eggplant emoji accusation should impress upon the court the plaintiff's and his counsel's abuse of this litigation. No, what it should impress upon the court is that he's dealing with some very mentally unhinged people, including Bruce Manskin and all of his little minions that he has pulled into this case to attack Jeremy Hales. So in conclusion, he says the plaintiff's motion was clearly filed to incite the court, placing these events in motion. It is contrived to generate and has generated a lot of YouTube content. My God, he just never stops with this. Never. He never stops. He knew it was a high-profile case. He entered the case because it was high-profile, because he wanted to get famous off of it. He wanted coverage on his mac and cheese case. And now he's complaining that it generates a lot of YouTube content. Make it make sense, because this doesn't. When the court looks at the contrived basis for the motion and considers that it was filed without the required certification to influence the court to act before the undersigned responded, it should strike the motion and vacate the order to show cause. If the court denies this motion to strike, the defendants respectfully request 1 week from that denial to file a comprehensive response to the motion for sanctions. Well, I mean, it sure seems to me like he's already responded to it, but we'll see. So here's what happened next. So Randy, he replied to the motion to strike. He said, and this is only 3 pages, plaintiff filed a motion for sanctions, including judicial default. Plaintiff's motion for sanctions is a motion for judicial default and dismissal of counterclaims. This means it is a motion that would determine the outcome of a case or claim. Therefore, an attorney conference and certificate is not required. Oh my God, color me shocked. You mean Bruce doesn't understand federal laws and rules? He doesn't understand the rules of procedure in federal court? I'm so shocked by this, yet again. He always reads it wrong. Therefore, the attorney conference and certificate is not required. See Local Rule 7.1D. An attorney conference and certificate are not required for a motion that would determine the outcome of a case or a claim. Boom, roasted. Moreover, defendant's motion is improper. This is because it is a big surprise. This is because it is a motion filed without a good faith to resolve the issue through a meaningful conference with an attorney for the adverse party. So the very thing Bruce is accusing Randy of doing, he didn't do, and he was required to. Defendant's counsel, so Bruce, sent an email yesterday at 12:42 p.m. alerting of the proposed motion. Plaintiff responded at 8:33 p.m. stating, counsel, the motion to request dispositive relief, judicial default, and dismissal with prejudice of your 2 counterclaims, see local rule. We will be seeking judicial default and dismissal with prejudice of your 2 counterclaims on April 3rd. See Exhibit 1. Instead of a conference about this, defendant's counsel filed the motion at 10:05 p.m. An email or other writing set at or near the time of filing the motion is not a meaningful conference. See Local Rule 7.1b. Additional examples for April 3rd, 2025 are attached, and this is not exhaustive at this point. In other words, we have a lot more of his bad behavior. See Exhibit 2, hashtag Hales hates the truth and hashtag Randy Shockett clown. Uh-oh. So did you notice that in Bruce's little motion, he never mentioned the clownsel? I guess he can't say that it's a typo now when he's created a hashtag called Randy Shockett Clown. Let's look at those exhibits. This is the one. Let's look at Exhibit 2. This is a Facebook post by Bruce Matskin, which, by the way, he has deleted. He is scrubbing all of his Facebook. He has scrubbed everything because he knows he's in trouble. He posted this, a short clip about my litigation opponents in federal court in Florida. Lawyers will know what I mean when I say they are committing the worst Rule 11 violation you've ever seen. Their lawsuit is a polyflop scheme, protraction of litigation of multiplication of proceedings to generate ongoing litigation-related storylines for YouTube content. It's the litigation along the way, not the outcome. That is the point of the lawsuit. The coming lawsuit against them will be historic. Now look at this. Hashtag Randy Shockett Clown. So, yet again, he cannot say that he didn't do this, that he didn't call him these things, when he's literally posting Facebook posts about it. And he can't say that it wasn't about the federal case because here he is saying this is about the federal case in Florida. This guy is in trouble. All right, so then this happened. The judge, Judge Bolitho, put in an order about the motion to strike. Defendant's motion to strike is denied to the extent it sought to strike plaintiff's motion for sanctions. So in other words, Randy was right. Randy did nothing wrong. He did it according to the rules, and Bruce is wrong. It is granted to the extent it sought an extension of the response deadline for the motion for sanctions. Defendant's response deadline is extended to 5 p.m. Central on March 25th, 2025. So he's just given him more time to gather more rope on which to hang his silly self with his dumbness, because that's exactly what's going to happen. He says, because every motion or filing in this case seems to beget another motion or filing, in other words, we're getting papered to death, the court will go ahead and preemptively state the plaintiff will not be given permission to file a reply memorandum in support of his motion for sanctions. So there is no need to file a motion asking. See the Florida rules stating that parties ordinarily may not file a reply memorandum in support of a motion unless the court grants leave. And Judge Blytho is saying, no, no more. Speaking of Judge Blytho, I was told by someone who knows a family with the same last name that the correct pronunciation is Blytho, like Blytho. So we've all been saying it wrong. It's Blytho, which is interesting and makes sense because it's Welsh in origin. And if you know anything about the Welsh language, it makes no sense as far as the letters used. So I think that it's Blytho. Anyway, that's what I'm going with until we figure it out. So the court has denied Bruce's motion again. So all of that nonsense about, he didn't do the right thing. Randy did the wrong thing. He's wrong again. And I don't have my buttons, so I can't play denied, sit down. But that's what I would be doing if I did have them. But how embarrassing. How embarrassing for him. And I don't think that it's any big gift that he's given Bruce more time to respond, because there is nothing Bruce can say that is going to get him out of this deep, deep doo-doo that he finds himself in. And this is his fault. It is his fault entirely that he is where he is in this case. So that's that. And you're all caught up now for what has happened in this case as of today. And I'm sure that Tug's broadcast this evening was all way more, way more in depth. But I wanted to give you my thoughts on it and keep you up to date on what's going on over here. Phoenix weather is lovely, but I haven't been able to be out in much of it because I've been really sick. I got out today. We went to ASU, my alma mater, sort of, because I didn't graduate from there, but I did go there for a year. I got to show my daughter around campus for a little while, and then I got really tired. So I'm back resting, and hopefully I will feel better by tomorrow, and we can go do some more fun things. But you guys take care. Thanks for tuning in, and stay tuned, because for sure this case does not disappoint, and we will be back with more very shortly.